We'll proceed for our third speaker this afternoon, after which talk we'll have some discussion with all the speakers today, and you'll have the opportunity to ask questions and to maybe hear some other things that you would like to hear from our presenters this afternoon. And our third and last speaker this afternoon is Professor Mikhail Karayanni. Professor Karayanni is the holder of the Bruce Wayne Chair in International Law at the Faculty of Law at the Hebrew University of Jerusalem. He was the director of the Harry and Michael Thatcher Institute for Legislative Research and Comparative Law and the Minerva Center for Human Rights. Professor Karayanni held visiting positions at Stanford Law School, Yale Law School, and the Institute for Advanced Study in Princeton. His research interests are in private international law and interreligious law, exactly what we're interested in, and multiculturalism and civil procedure. Please, Professor Karayanni. And Professor Karayanni's talk he will speak on liberalism divided, religious accommodation of groups, and secular protection of individuals.
Well, it's an honor to be here. I had the pleasure of meeting Lord Wolf about 3 years ago at the House of Lords, and I'm very much acquainted with his work on access to justice, and there must be kind of a connection between religion and civil procedure. Obviously, both of us engaged in both topics. So this is the topic of my presentation. It has to do with religion and state in Israel. It's a very Israeli study. In Arabic, we have a popular quiz when we ask our children to name the object from which you can take more and more, and it only gets bigger. And this is the project about religion and state in Israel, at least from my perspective. Because I went and tried to discuss the issue of religion and state from the point of view of the Palestinian Arab minority in Israel, whereas so far it has been discussed only from the Jewish perspective. Religion and state in Israel is an intra-Jewish discussion in the state of Israel. And I got a very generous research grant from ISF to try and see why. And it all started with this entry in Israel's major constitutional treaties. When I looked up religion and state, Datu Medina, I found this entry, C, a Jewish state. If you would open any book, any article dealing with religion and state, it would be Jewish-centered. Even the kind of people who have researched this topic come from a particular stream. So I asked myself, is that a coincidence, or it has to do with a paradigm, with a kind of a theoretical configuration that has led the discussion? When I've presented this work, I was faced with the argument, well, you Arabs do not petition the Supreme Court on religion and state. Well, that's not true. All throughout history, there was a lot of Supreme Court cases dealing with religion and state issues that had to do with the Arab minority. One of the first Supreme Court decisions, it's called Milham versus the Sharia judge in Acre. And it had to do with outlawing polygamy. Polygamy was outlawed. It was considered to be a crime also for Muslims, whereas during the British Mandate, Muslims had a defense. And leaders of the Muslim community came out saying this is something that infringes on our freedom of conscience and religion. This is very religion and state. And the list can go on and on. Sultan versus Sultan, an extremely interesting case. A Muslim woman was unilaterally divorced by her husband, a divorce that is considered to be valid in Israel, even though it's a crime. And she brought a civil action, arguing that you have committed a civil wrong against me. And that was recognized. Religion and state, consider that being argued in Europe today. Of course it's religion and state. But why is all of this absent? Why, when we come to the issue of religion and state, it's just Jewish? Is that the syndrome of the present absent? A lot of Arabs are present in Israel, but under the law in Israel today are absent. Is that the same syndrome? I don't think so. I think the issue is, first, there's a considerable Palestinian Arab minority. It's very diverse religiously. You have 10 different Christian communities that are recognized under the law, each with the power of establishing a court and applying the laws on marriage and divorce as they wish. And I think I have come to theorize this. Religion and state in respect of the Jewish majority in Israel is characterized by two basic attributes. One, Judaism is an established religion in the state of Israel. It's part of Israel's public sphere. We just heard how. Judaism in Israel is not just like any other religion. This is the Jewish state, and Judaism happened to define it. One indication is this website from the Ministry of Religious Services. It's called the Ministry of Religious Services, but when you read into the website, you would find that it's only concerned with the Jews. You can just read it. It's from their website. A Supreme Court judgment given by Justice Rubinstein. In his obiter dicta, it was not needed for the particular decision. He said in a mixed marriage case between a Christian and a Jew, he said this, the reality of mixed marriages, it's part of a bleak, depressing reality. And he went on to saying this is from a Supreme Court decision in Israel. If it was up to me, I would not hesitate to convince each and every Jew in the country, متعامين ربيم, from very good reasons, لينسل ابنها عام يهودي, to marry only Jews. There would be no other person that would be more happy than I, certainly after the Holocaust, when the Jews lost a third of their people. This sentence cannot be said, but only in a state in which Judaism is an established religion. It has nothing to do with the identity of this particular judge as a Jew. Today there are 3 Jewish justices in the US Supreme Court. I would imagine none would dare saying that a mixed marriage is part of a bleak reality. I would also venture in saying that no Arab justice in the state of Israel, certainly not a justice with these ideas, would say mixed marriages between Muslims and Christians in the state of Israel is part of a bleak reality. If it was up to me, I would want the Palestinians to be one. This would not be said in an Israeli Supreme Court judgment. And I think this is telling. Zerah Warhaftig, who was a preeminent Knesset member from the Mafdal, and there were, at one time, a different kind of Knesset members, very learned, educated in all fields, and he was very opinionated on many matters on religion and state. And when he spoke of what defines Israel as a Jewish state, he said this, and this is what I have highlighted. There are 2.5 laws that define Israel as a Jewish state. One is the law of return, but the second law is the law of marriage and divorce. This is what Rubinstein was just saying. But it's the law of marriage, of divorce, of one sect in Israel. So Judaism is an established religion, and it's part of Israel's public sphere. The other attribute is that when a rabbinical court enforces Jewish halakha on Jewish members, it's considered to be an illiberal act in Israel. This is religious coercion. This is not something which is part of Israel's real democracy. This is something which is a necessity. This is something to preserve the Jewish identity. Or some would say it's a necessity because of government coalition considerations. Some would say it's consensual democracy. But this is a necessity. And you would find a lot of people speaking about the rabbinical court's jurisdiction as illiberal, as coercive. And this is Chaim Cohen speaking in his own autobiography. The rabbinical jurisdictional authority over matters of marriage and divorce is a blot on Israel's democracy. And here where things differ. My thesis is that when it comes to the Arab minority, their religious accommodation is not public, but it is private. And second, it's not coercive. It's not considered to be illiberal, but considered to be on the group level a liberal accommodation for the Arabs. And this is a text taken from a Ministry of Foreign Affairs booklet. It's propaganda, it was obvious, but nonetheless, it is telling, and I think it is telling because it is of such a kind. And here, the Ministry of Foreign Affairs is bragging, is taking special pride in how Israel, as a Jewish state, has maintained the jurisdiction of the Christians and of the Muslims. Whereas in Egypt in 1956, Israel's arch enemy back in 1961, Nasser has abolished these religious courts. You would not be saying this unless you are confident of the fact that what exists here in Israel is liberal, and it is liberal on a group level. Look at Nasser, what he has done. He has abolished these courts, but we are maintaining them. And so the same jurisdictional authority that is perceived coercive for the Jews is conceived to be liberal. But liberalism does play a part within the religion and state conflict in Israel in terms of the Jewish majority, but it plays a part in protecting the individual against the religious authority. But in terms of the Arab minority if you would accept my thesis. Liberalism is protecting the group, the religious group, and not the individual. And if you would accept it, and I'm very much convinced of it, then there are a number of implications, normative implications. Because if your mindset in perceiving the same religious authority, one coercive, one of being liberal, and you come with a liberal mind, then you would protect the individual more when he is a Jew, but you would protect the group, the religious group, more if it's an Arab group. Let me give you 2 examples. And I'm happy that Justice Barak here, because he wrote this decision. It's called Jabberin versus the Minister of Education. This is the case. This is the veil case of Israel. This is a case of, I call, Muna Jabberin of Nazareth. It's not Jesus of Nazareth, it's Muna Jabberin of Nazareth, and this is why. Muna Jabberin was a Muslim student from al-Fahim who wanted or who sought admission in a Catholic school, a very prestigious Catholic school in Nazareth. And you would imagine why a young girl of 14, 15 is willing to travel each day back and forth between al-Fahim and Nazareth to get into this school, saying a lot about the school system in al-Fahim. But let's leave that aside. Now, she wanted and she sought admission. She passed all of the entry exams. But the school said, well, you're coming here with the veil, and we're not willing to admit you. There are certain activities here that you need to take part in. Physical education, maybe even swimming, and you cannot take part in these activities unless you would be able to take off the veil. She petitioned the Supreme Court, saying what the school did is an infringement on my freedom of conscience as a Muslim. Now, grant me the assumption that what she did, or her claim, is really a liberal claim seeking accommodation, remedy, in the name of the freedom of conscience and freedom of religion. Her petition was denied. The Supreme Court said that this is a private institution, private, right? Even though it's not accurate, I think, with all due respect. This is a private institution that belongs to a recognized millet, the Catholic. And therefore, your petition against it would infringe on that group's freedom, let's say of association. So liberalism is protecting the group against the individual. The individual did not come first. What came first was the group. And Justice Barak at the time continued saying that if this was a public institution, I might have, or I will reconsider, or I might have came to a different conclusion. So let's say if Muna Jabberin was coming into Bar Ilan University with her veil, I don't think that the Supreme Court would be as supportive. But the Catholic school in Nazareth, about 80%, maybe a bit less, of its budget comes from the government. It's a recognized, accredited school, which is private. But nonetheless, about 80 or 70% of its budget come from the government. So it's not totally private, but that's the paradigm. Now let's compare that with the Sheikh De'el case, which is very known in the Israeli public. A religious activist woman sought admission to the religious council in Yeruham, and she was denied admission just because she was a woman. She petitioned the Supreme Court, and she won. Her liberal right of being equal or being treated equal was enforced against the religious council's right of freedom of association. This is how we conceive our religious values. And because that specific religious council, as all religious councils in Israel are recognized by statutes, administrative law was applied, and according to usual administrative law norms, you cannot discriminate on the basis of sex. But then, who do we recognize by law when it comes to religious institutions? How many laws do we have in Israel recognizing Christian institutions? Can anybody name me one? Christian judges are appointed to the Christian courts without any process of law. I, the archbishop, think that this guy is appropriate, and I can appoint him, and only him, God forbids. And when you come to court, what guarantees me due process in terms of that court's norms? I cannot get a divorce as a Christian in Israel. Is that liberal? Of course not. But nobody discusses it. Why? Because it's not part of the discussion. And why it's not part of the discussion? Because of the paradigm. Because what we grant you in Israel in terms of a religious accommodation is on a group level considered to be liberal. And you have all these various laws that are recognized on the Jewish side. Rabbinical courts, a law. Dayanim, a law. The chief rabbinate of Israel, there's a law. Jewish religious services, religious councils, law. Law regulates kashrut, kosher food for the soldiers, the issue with the mezuzot, even the place of residence of rabbis. This is all regulated by law. But why? Because it's part of Israel's public sphere. This is our established religion. And once it becomes governed by certain administrative law. But when it's not, it's beyond administrative law and beyond the norms that would assure equality. Now, when I try to see where did it come from? I mean, was it out of the blue or did it come from something? And this is my current project, this whole that is becoming larger and larger. And when you look at the basic documents actually that defined the Israeli-Arab conflict, there was a conditioning between the recognition of a nation state and accommodating religious minorities within. And that conditioning created the presumption that what is granted to the minorities is liberal. It's a concession on part of the state. When we discuss the Balfour Declaration, we always deal with the first part, but look at the second part. Reception, respect for the personal status of the various peoples and the religious interests. UN Resolution 181, Article 4, the family law and personal status of the various minorities and their religious interests, including endowments, shall be respected. The British mandate over Palestine. And it goes on and on. What I'm trying to say is that once Israel was created as a Jewish state, at that same moment, it was perceived that what is given to the non-Jews in Israel is a liberal concession when it comes to their religious affairs. And what I try to say that this has implications. Now, when I present this work, people are kind of puzzled because when an Arab speaks about an Israeli law that deals with the Arabs' group rights, it's like a left hook. I mean, what are you saying? Is Israel too liberal when it comes to the religious accommodations of non-Jews, when it comes to their religious rights? And my answer is yes. I think Israel has been much more liberal, and extremely much more liberal when you would compare this liberalism when it comes to the Palestinian Arab minority as one national unit. As one national unit that is confronted by the established Jewish nature of Israel. There, the concepts of group rights are very thin, if at all. But in terms of their religious accommodations, it's a very thick concept. But this liberalism was not that innocent, and you should not be taken by the presumption that everything that is seen as liberal is really innocent. It was motivated by divide and conquer. This maintains the divides. And, well, the Druze are seeking recognition. Let's give them. Why not? No problem. The Anglican Church, a church of maybe 2,000 in Israel, are seeking recognition. Yeah, why not? If you want recognition, we're willing to give you. It divides you. It makes it more possible for us to control you as a minority. And it serves your patriarchal system. I'm not saying that the Arab minority was not interested. It was very interested because it's patriarchal. But patriarchy serves also established interests of maintaining that group as it is by reinforcing certain social constructs. So it's liberal, it might be even very liberal, but it's by no means innocent. Thank you.